everyone, I am Gopi Krishna from Glorious IAS Academy. Today we will talk about intellectual property rights. There was a news item yesterday. The headlines was US puts India on priority watch list for alleged IP rights violations. This is the headline of the news item. Basically, what US is alleging that the IP rights regime in India is weak, and we are not doing enough to protect the IP rights of the US companies. So India will give appropriate response to this, and the main allegation they are putting is we are having high import duty on high technology products in India, and second is the enforcement is not very strong, it's weak, piracy is there, and other counterfeit goods are there, and thirdly they are opposing the clause 3D of Indian Patent Act also. We will see inside what is 3D, we will have a discussion on that. So primarily this is the US allegation, but India will give appropriate response, and because India is following all the TRIPS agreement conditions. So in this backdrop, using this as a base point, let us see what is the intellectual property rights regime in India in detail. So what are intellectual property rights? As you all know, these are the legal rights that protects the creative works. Somebody who is creating the work, they will protect the legal rights. For example, new medicine, new product, a new mobile phone, books, trademarks, like that, everything whatever is created, because the creativity has to be promoted and the creator has to get some benefit. That's how we can promote the creativity. So the exclusive rights will be given to the creator, and nobody else can copy that, nobody else cannot replicate it. So for patent, for products different rules will be there, for copyrights different rules will be there, for trademarks different rules are there. We will see all that. And so the for the creator gets a royalty. So royalty makes the product costly, but in long run society will gain from this. How? By promoting the creativity. Without royalty he won't create, so new ideas won't become, no creative products won't come, and economy won't move forward. So basically these are the features of intellectual property rights. It rewards the creator, it encourages innovation, because many scientists, many people, they innovate because they want to have the exclusive right, they want economic benefit also, and they want to help the society also, because economic benefit also plays a key role. And it protects the business, because they are investing a lot into the R&D and making the product. So they want to get economic benefit out of it. So if you protect IPR rights, then only their businesses will be protected. And it drives economic growth of the country, because if you have more innovation, more R&D, then you can make high-end products, the products which are competitive worldwide in the international market, so we can export. So that's how economic growth will be made. By making average and normal products, our economic growth won't be so fast, so high. So who manages, who implements this IP rights in India? Basically this is the Ministry of Commerce and Industry it will come under, and the department is Department for the Promotion of Industry and Internal Trade, that is DPIIT. It comes under which ministry? Ministry of Commerce and Industry. And what is the office? The exact office is Office of the Controller General of Patents, Designs and Trademarks. So people will apply there and processing will be done. So this is the ministry. We will come to copyrights. Basically copyrights means it's about books, it's about artwork and other creative works. It is different from the products. So in copyright there is a protection of expression of idea, not idea itself. You must have read it. I want to simplify it. So let us see this with an example. What does it mean? We protects the expression of idea, not idea itself. So if you see an example, if you see any movie, romantic movie, what is the storyline will be? A hero approaches heroine says no, and later a heroine agrees to the hero's proposal, they fall in love, and then they face some challenge. Maybe heroine father won't agree, or hero father won't agree, or there will be a caste difference or class difference, and then they finally come together, they overcome the challenge, and then they live happily together. This is an idea. You cannot copyright the idea. If you copyright the idea, nobody else can make movies on that, and it stifles creativity. But the expression of idea can be copyrighted. So say in movie Upena or Kadal, they have used this idea, and all movies use the same idea only, but the expression will be different. There will be unique expression, character development will be different, plot will be different. So that's how it protects the expression of idea. That expression cannot be copied. For example, in Pushpa, they say, whatever the dialogues or mannerisms are there, they cannot be copied. But Pushpa story is all about rise from rags to riches story, which that story can be copied. So this is how you have to understand, and copyright is given to expression of idea, not idea itself. Copyrights you need not register, they are automatically protected under Copyrights Act 1957. This is the act under which copyrights are protected. The copyright is valid for 60 years after death of the author. So till 60 years the copyright is still valid. So even if the author dies, the books can be sold in his name by the appropriate company or publication or whatever the agreement they have. So next we will come to patent. What is a patent? Patent, it's an exclusive right granted for an invention. Patent is mainly for goods. Patent holder can exclude others from making and selling the products. No other person can make the product, only he can make the product. And in the disclosure, there is a compulsory disclosure. The inventor has to give the technology with which he is making the product. So that will help promotion of the technology. Others cannot copy the technology and make the same product, but they can use the technology and get the ideas and make new products. So patent is valid for limited period, 20 years only, from the date of application. It is exclusive, it's only for the inventor, and it is territorial. Suppose a person invents something in USA, it's not automatically patented in India, he has to apply again here. The inventor has to apply for the patent, not automatic. In copyright we have seen it's automatically protected. He need not apply. A book you have written, the copyrights are protected. But here in the patent, inventor has to apply and he get a patent certificate. So the patents are administered under Indian Patent Act 1970. So evergreening of patent. In the first slide we have discussed US is against application of 3D of the Indian Patent Act. That is related to evergreening of patents. What does it mean? Suppose a pharma company is there, it has a unique product, a life-saving drug which is very costly, and it is patent is valid only for 20 years. After the end of 20 years, some of the pharma company, what do? They say they make minor modification in the product. They again want to extend the patent for 20 more years. So this is called evergreening of patent, and India is against this because we want generic drugs for safeguarding the health of the poor and middle class of the country, because we can't afford that. So basically pharma company is making minor modification without any increase in therapeutic effect of the drug. Suppose if the drug is innovative and it has higher therapeutic effect, then that's fine. But with the minor changes, they cannot evergreening the patents. They cannot extend again and again. Basically because it delays the manufacture of generic drugs. This is the case study. It's a old case study. It's happened in 2013, but it's a landmark case. So we can see this. We can learn about this. It's a Novartis company. There is a Glivlec, a life-saving drug for leukemia patient. It costs around 1.2 lakhs per month. So they tried to extend patent after 20 years with minor modifications. Supreme Court struck it down and said that the new product doesn't have any extra therapeutic effect. Basically now the generic drug costs around 3,000, 4,000, 5,000, around that, 6,000 per month. So there is a drastic difference between the patented drug and generic drug. But we need patented drugs also because they innovate and bring out new drugs. So that's how it's like in short run he will earn money, but in long run it benefits the society. That's how it works. So trademark, the moment trademark we hear, we can remember Nike symbol. the tick mark or Apple logo with a half-eaten, bitten apple. So basically, it's a powerful way you can build your brand. It could be a name, word, phrase, logo, symbol, design, image which distinguish one good service from others. So it protects the brand image and it's a permanent one. Once you register your trademark, it belongs to you. The Trademark Act 1999 is through which trademarks are registered. They can be transferred also. It depends on the company or the inventor. So what is a trade secret? This is another aspect of IPR regime. For example, Coca-Cola recipe is there. It's a highly guarded secret. Very few people know it. Basically, it is a secret and it has a commercial value. That's what the TRIPS says about trade secret. What comes as a, what can be designated as a trade secret. It should be a secret and also it must have a commercial value. And basically it can also be having about a sales strategy, distribution strategy also. Basically it has to be decided on case to case basis what comes as a trade secret, what doesn't come as a trade secret. Basically a lot of industrial espionage also happens so that they can make better products and they can win over other companies. And another aspect in this is GI, geographical indicator. You must be hearing about this in news. And basically GI, to which product we give GVA is the product derives a specific quality or reputation because of that place. It's not like other people cannot make that product. But by giving a GI tag, the market value increases, the brand value increases because it has a special quality to that. Basmati rice, Alfonso mangoes, Nagpur oranges, etc. In every state we have this. And these are administered under Geographical Indicator of Goods Act 1999, Registration and Protection Act. We can also relate another Government of India scheme with this, one district, one product. This is being basically what Government of India is trying to do is every district should come up with one product where export potential is there, where economy can be built around it and ecosystem can be built around it. So this is being administered by Ministry of Food Processing. One district, one product can be related with GI because when the district is coming up with one product, usually the GI products are the best suitable candidates because they already have a international name, national importance and popularity. So we can promote that also. But this is a different related to GI. We are just relating it. So another is traditional knowledge. India is trying to promote traditional knowledge. We have a scheme for promotion of traditional knowledge into digital library. And regarding patents, some people are trying to use the traditional knowledge and get a patent. For example, turmeric has wound healing techniques. Everybody know it from ages. So some company comes and tries to patent a product around it. Government of India prohibits that through Indian Patent Act 3P. Basically the inventions that are essentially from traditional knowledge, they are prohibited. You cannot do that. And inventions that are merely an aggregation or duplication of known properties of traditionally known components. So by a combination of some Ayurvedic compounds, you cannot make an invention and say, this is a new drug and give me a patent because everybody knows and it's part of our traditional knowledge, it's part of our heritage. You cannot make royalty out of that. So TRIPS. So entire IP regime, we are implementing based on the TRIPS because we are WTO signatory member. So they said you have to, the TRIPS agreement came to effect after Uruguay round of talks on 1st January 1995 and the deadline for the developing nations was by 2005, we have to implement 1st January 2005. So we had to amend the Patent Act 1970 suitably. Especially there was before amendment, we used to have we didn't have product patents in drugs. Only the process of making of the drug was patented. The drug per se as a product was not patented. So it used to allow generic drugs. But WTO said no. To agree for the TRIPS to comply with the TRIPS agreement, we have shifted we made suitable amendments. Now product patent in drugs are also available. But there is a risk. If product patents are available, the companies can become monopolized and they may put the drug at a very high cost, which is not accessible to the poor people. So, to protect the developing nations, poor nations, WTO also gave a concept of compulsory license. We will see what it is in the next slides. So what are the features of TRIPS? Features of TRIPS are comprehensive protection of IP rights in the member countries. What they think is all the countries, if the patent is there in one member nation, so other member nations also should respect the patents. And there should be a emphasis on enforcement. Just by registering the patent, nothing can be done. Ultimately, there should be a enforcement on that. That is to say, if piracy is there, that should be stopped. If counterfeit goods are there, they should be stopped. At the import also, you have to check the counterfeit goods, for example, like that. And the procedure should be fair and equitable, the enforcement procedure. And generic drugs, we will see what is compulsory license. Suppose if a patented drug is very costly, to reduce the cost, there are some mechanisms. First mechanism is voluntary license. The patent holder will come into agreement with a third party person and they will make a drug which is at a lower cost and they sell it. So voluntarily we are getting a generic drug. That is one way. Second way is compulsory license. When a company is abusing its monopoly position and when there is a national epidemic like corona, then government of India can impose a compulsory license. They can say ki someone else can make this drug because of the public interest, but royalty will be paid to the company. This is the compulsory license. So basically WTO is giving a mechanism for the developing nations and also poor nations that the patented drugs can also be obtained at a cheaper cost if the need arises. In Doha Declaration also this was reaffirmed. WTO members to use compulsory license to address public health problems including HIV/AIDS, tuberculosis, malaria and other epidemics. So basically the concerned country can decide which is an emergency situation. So in the emergency situation the compulsory license criteria is used so that the drugs are obtained at a cheaper price to the poor people. We will go back to that slide. So finally we will also see National Intellectual Property Rights Policy. We have National IPR Policy 2016. It's a old policy, but let's refresh. The slogan of the policy is Creative India, Innovative India. So we want a creative India which is innovative also. So what are the components of this? First is IPR awareness, so that more people know about intellectual property rights, so their creative ideas can be registered and they make more creative products and services. So basically for promotion purpose we have included the content in NCERT also. And generation of IPRs, we want more IPRs to be generated. Legal and legislative framework, whenever there is a dispute, there should be a legal framework to adjudicate that, and appropriate amendments should be done. And administration and management. Digitization is done, automatic issuance of electronic certificate has improved the efficiency of giving the patent registration. So, and commercialization of IPRs, just registering won't do, they have to generate some economy around it, to the inventor also, to the country also. Enforcement and adjudication, this is also important component of the IPR, and on this issue also US is trying to pressurize India by putting us on the watch list. Maybe it's Trump's tactic of pressurizing India. India will give appropriate response on this because enforcement is also good in India. So the development of an IPR enforcement toolkit for police has been a positive step. For police some toolkit has been given, and human capital development of for the IPR also. And in this context you must be aware the Global Innovation Index in 2015 our rank was 81, and in 2024 we reached the rank of 39. It's a huge progress because the policy also helped us. Our entire ecosystem is designed in such a way that we are promoting and protecting IPR. And rural innovations. In this context, we will see there are two schemes for rural innovation. I just wanted to mention this. One is Aspire, a scheme for the promotion of innovation of rural industries and entrepreneurship. The scheme is by the MSME ministry, and it aims to promote innovation entrepreneurship in rural and undeserved area. And another is Atal Community Innovation Center. They also act as incubation centers for promoting innovation. National Innovation Foundation in India, an autonomous body under the Ministry of Science and Technology. It identifies rural technologies and they try to scale it up. They promote rural innovation in the country. So this is from my side, friends. I am Gopi Krishna from Glorious IAS Academy, and this IPR, intellectual property rights, is a very important topic for not only UPSC prelims, for other competitive exams also. And so today, as a current topic has come, US kept it as an watch list. So from that perspective, we have seen it, and India also will give response, so it will be in current news. So I wish it will be helpful for you. Thank you very much.